Hi, I'm Louisa Sijabat, a liquidator and bankruptcy trustee. So today's question is, my client's company has ended up in liquidation. This is because there was a debt that was disputed, but my client didn't do anything about it at the time, and now the company's ended up in liquidation because the court's ordered for its liquidation. Should my client apply to the court to have the liquidation set aside and the company restored to him? So, the answer to this question is that it depends on a very large number of factors, but essentially it comes down to a cost-benefit analysis. So, in order to apply to the court for a liquidation to be set aside, the company generally needs to be able to demonstrate that it's solvent. That is, that it can pay all its debts as and when they become due and payable. Now, this is not only the debt that caused the winding up or the debt that was disputed, it relates to all debts of the company. And it has to be, in the liquidator's opinion, generally, that the company is solvent and can do so. So, the company needs to be able to demonstrate, whether through current resources, borrowings, other cash sources, future cash inflow streams, that it can do so. Now, for most companies, this is usually quite hard to demonstrate. Sorry, most companies that end up in this process or in this situation, it is usually quite hard to demonstrate. On top of that, the liquidator will have started work and will have incurred fees and disbursements, which usually also need to be covered if a liquidation is going to be set aside. Now, on the benefit side, what does the company director or its shareholders gain by having the liquidation set aside? So, to what extent are there assets in the company? To what extent are there things worth saving or defending? And I'm particularly thinking about licenses, registrations, contracts, what's worth keeping in the company that would otherwise get lost in a liquidation? And is that more or less than the cost to set it aside and the cost to keep the business of the company running? Now, if you're in this position, please seek legal advice right away from an experienced insolvency lawyer. So I'm a liquidator, I'm not an insolvency lawyer, but if you get stuck, I can recommend a few good names. But the main thing is get onto it quickly. There is quite a high threshold of things that do need to be demonstrated. It's not impossible to do, but it does have its challenges, so please do have realistic expectations as you go into the process.